Hi, I'm Michael Warshauer. Over the next 20 minutes or 25 minutes, I'm going to be telling you about the Federal Employers Liability Act. The Federal Employers Liability Act is an act of the United States Congress. It is found at 45 United States Code, Section 51. Basically, it provides that railroads have a non-delegable duty to provide their employees a reasonably safe place to work, reasonably safe tools, reasonably safe coworkers. This act was necessary because 100 years ago, the average life expectancy of a railroad worker was about 6 years. Go to work, be dead in 6 years. And Congress said, railroads can't burn humans up like they do coal. Human beings deserve better than that. And that's why this law was enacted. Here we are a century later, and this law remains a necessary and vital aspect of railroad safety. Not only does every single railroad union agree that the Federal Employers Liability Act remains an essential and important aspect of safety, but so does the United States government. And the reason is this: only through laws such as the Federal Employers Liability Act can the railroads be caused to pay the real cost of human injury. And only when they are charged with the real cost of human injury will railroads make safety a first priority. What is this safety I'm talking about? What is a safe place to work, as Congress defined it a century ago and as it continues to be now? First off is safe and adequate tools. That means safe switches, safe lanterns, safe hand tools. Safe and adequate lighting. That means at night, if you're in a yard, you're going to have adequate lighting. It means safe and adequate walkways. That means where you're going to walk on a regular basis, you're going to have yard ballast. That's like driveway gravel. You're not going to be having to walk on bridge ballast the size of a basketball. You're not going to be required to walk on road ballast the size of tennis balls. The railroads have a duty to take care of your ankles, your knees, your low back, and to prevent slip, trip, and falls by making sure your walkways are free of unnecessary hazards and that your walkways are adequately covered with the right kind of rock. Safe and adequate assistance. This is all the more important in modern railroading because it used to be, even 20 years ago, railroad workers came to work, they cubbed for a long time as brakemen and trainmen before they became conductors. Now they go to school and they're expected to know everything right away. Unfortunately, that kind of training is not adequate to prepare them for the rigors of modern railroading. Cubbing in a place one night and then being expected to know how to switch it is not the kind of training that makes for a reasonably safe place to work. And this law provides that if one of your coworkers makes a mistake that causes you an injury, the railroad's going to be liable for that. Safe and adequate time. We all know that railroads are driven by time. We have watches that are assigned to railroad men that have to be of a certain quality. Customers need their cars on time. Trains need to be on time. You got to be at work on time. Well, sometimes this pushes people too hard. And when people are pushed too hard and they're working too fast, tragedy is sometimes the result. And when that tragedy could have been avoided by good management practices, the railroad's going to be liable. Safe and adequate training and instruction. I touched on this a minute ago, but sometimes a 6-week school is not enough. One night cubbing on a job is not enough. Real training, real experience are necessary for a safe workplace. And when the railroad fails to provide that kind of training and experience, the railroad's going to be liable. What is the basis for this liability? It's not just that something happens at work that makes the railroad liable. No, the railroad has to be negligent. Negligence means the failure to do something a reasonable person would do. If it's foggy outside and raining, a reasonable person slows down on the highway. Similarly, if we use the walkway example for railroads, a reasonable railroad would provide good ballast, adequate lighting, adequate time. Negligence is also the doing of something a reasonable person would not do. Again, using the car example, if it's rainy and foggy, you don't violate the speed limit by going 90 miles an hour. You drive even slower. Similarly, railroaders should not be compelled to do unsafe things like work past their hours of service law, or not have adequate rest, or not have adequate assistance, or be compelled to work with switches that haven't been lubricated. Basically, negligence is carelessness. It's just being careless. But I want to remind you that just because a railroad has always done it one way does not make it reasonable conduct. Sometimes I use the phrase from a Hank Williams Jr. song. People ask me, Hank, why do you drink? Why do you smoke? Why do you live out the songs that you wrote? His answer is it's family tradition. Well, the railroads often say that. Oh, that switch is no worse than any other switch in the yard. Or that ballast is like all our ballast. Well, you know what? That doesn't make it right. That switch should be predictable. That ballast should be safe, level, and adequate. As I said, history does not equal reasonable conduct. The fact that the railroad's done it over 100 years doesn't make it right now. In addition to this negligence standard, some parts of railroading were deemed by Congress to be so important and so dangerous that they imposed what's called strict liability on the railroad. That is, liability without fault, liability without carelessness, liability without negligence. These are called the Safety Appliance Acts. Grab irons, if there's anything wrong with a side ladder, steps out of a line, steps bent, grab irons broken. It doesn't matter if they could have caught it or could not have caught it through reasonable inspection. It could be an invisible hairline crack that could only be found through extraordinary inspection, say magnafluxing. They're liable if the grab iron fails. Similarly, handbrakes have to be efficient. That means they got to operate with quick release. That means the wheels have to turn adequately. It means that they have to hold the cars in place. Train line brakes. When a train is hooked up and ready to go, we all know that they are controlled through the use of air brakes. Sometimes the train will be running down the road, the air will shoot, nobody will know why that happened. The conductor will walk the train and he can't even discover a defect in the line. The air comes back up, they're able to go. But if somebody was hurt during that, when the slack came in, the railroad's liable, even without proof of carelessness or fault. If it happened, they're liable. Automatic couplers. Couplers have to couple automatically on impact. If they fail to couple automatically on impact, the railroad's liable if that occurs on a straight track. Similarly, when you go to pull a cut lever and the slack is in as it should be, and that cut lever doesn't come up and you get your back hurt, the railroad's going to be liable for that too. Now those are the basic Safety Appliance Acts. In addition to that, Congress passed what used to be called the Boiler Inspection Act back when steam locomotives were the common form of locomotive power, and now it's called the Locomotive Inspection Act. And it basically says that if any part or appurtenance of a locomotive is unnecessarily dangerous, the railroad is liable even without a showing of fault. Let me give you an example. Let's assume that the railroad buys the newest engine out there. They have it inspected by the FRA's head inspector. Their own machine shop certifies it as the single safest locomotive ever done. If a head gasket blows and 10 gallons of oil get on the running board through no fault of anyone's, freak occurrence, man opens the door, steps out and slips and falls, the railroad is absolutely liable. Because as I said, if it's a violation of the Safety Appliance Act or the Locomotive Inspection Act, fault is not necessary. All that is necessary is a violation. Sort of like speeding. You can't say, officer, I didn't mean to speed. If you're speeding, you're speeding. And that's the same thing with these statutes. In addition to these, there are certain regulations imposed by the Department of Transportation. And any regulation passed by the Secretary of Transportation, Federal Railway Administration, vegetation, drainage, also relating to couplers and handbrakes and locomotives, any of those regulations are violated, it's the equivalent of strict liability. I want to emphasize that this duty is non-delegable. What that means is it doesn't really matter if the railroad has a contractor do some things for it. You know, again, 20 years ago, the clerks carried everybody around, and now they're using Cimarron van, or they're using other kinds of taxi services to carry people from one end of the train to the other, or to a motel. The railroad can't delegate that duty out. If this van company gets in a wreck and it's the van driver's fault, the railroad's at fault. Similarly, it doesn't matter when you go on private track. It doesn't matter when you're on private property. You can be inside the gates of an industry on track that's entirely maintained by that industry or a subcontractor for that industry, and the railroad is liable if that track was defective and unnecessarily dangerous or not reasonably safe. As I said, the railroad's going to be liable for everything. That includes dangerous motels, a motel that catches on fire, or a motel that's in an unnecessarily dangerous neighborhood. The railroad needs to inspect for those things and make sure that your workplace is reasonably safe. I mentioned taxis. They're also liable for the equipment of other railroads. We've all seen rent-a-wrecks out there on the road. Some of these things just shouldn't be pulling a train, much less be in the consist. The railroad's going to be liable for those. And the railroad's going to be liable when you are on another railroad's property, for example, when you're running a pilot car or something of that nature. And the railroad's going to be liable for the mistakes of contractors. Too often modern railroading is subcontracted out. The maintenance of the way department doesn't cut the vegetation anymore. They sub that out to Asplund, or they have Sperry do their track inspections to see whether they have a split rail. They can't say, well, it's Sperry's fault because they didn't find this split rail, or it's Asplund's fault because they didn't find and cut down this tree that interfered with vegetation. Nope. If it happens at work, the railroad is liable if it was careless or a violation of a Safety Appliance Act or regulation. One of the best things about the Federal Employers' Liability Act is it treats you as a human being. You're not a number. You're not on a chart. You are someone who is treated as an individual. This law allows for actual damages, actual economic damages. That means your actual lost wages. If you make $80,000 a year, that's the wage we deal with, not some arbitrary amount as is done in workers' compensation. Lost benefits. One of the great things that unions have negotiated for and people have suffered for over the years is a benefit package in the rail industry which is second to none. It's approximately 40% of your gross wages, in addition to your gross wages, is your benefit package. Health insurance, vacation, railroad retirement board benefits. All of that's part of your real economic losses. In addition to that, you get your unpaid medical expenses. As I mentioned, you've got great health insurance, but if there's a copay or a deductible or something that's just not covered for one reason or the other, the railroad's going to be liable for that too. In addition to those special damages or economic damages, damages that you can add up with a calculator, the railroad's also going to be liable for what we call human damages, the ouch of pain, the physical hurt of being injured. In addition, the O of pain, that is, gosh, what am I going to do now that I'm out of work? What am I going to do? How am I going to take care of my family? Death cases are a little different. We often hear in television commercials, or maybe from our friends, or hopefully not our own families, the concept of wrongful death. It really doesn't exist in the railroad law the way it does in other cases. Instead, railroad law is a compensatory damage. What that means is anything that the man suffered or woman suffered before their death, pre-death pain and suffering, that money is going to be there to compensate them. In addition to that, there's lost economic support for people who relied on them. Let me give you an example. If two twin brothers both died in the identical event, a horrible train wreck, and it killed them both. One twin brother was single, spent no money on anybody but himself, and had no dependents, and died instantly. This law says that there's no one to compensate, and the railroads basically would get a free bite. As horrible as that sounds, it's a fair trade-off for all the good parts of the Federal Employers' Liability Act. But if the other brother had 5 children, never spent any money on himself, spent all his money on his wife, all his money on his children, those children and his wife would get all the money that he spent on them through their 18th birthday. In addition to that, these kids would get what's called loss of parental guidance. And that's just the value of, Dad, should I date this girl? Dad, should I go to summer camp? Dad, should I go to football practice? All of that's parental guidance, and that's compensable. And that makes this statute truly unique and makes it a wonderful protection for a family of someone who dies a tragic death at work. It's important to know how long you have to file suit. For Federal Employers' Liability Act claims alone, that is where the only party that's going to be liable is the railroad, you have 3 years. 3 years from the date you first knew or should have known of your injury. and its connection to work. This is pretty easy when you have a trauma. You fall off a car, you twist your knee on January the 1st, you know that 3 years from that date, your statute of limitations expires. And you cannot file suit after that. If you have not filed suit before that expiration date, your claim is lost forever. On the other hand, it can be a little more complicated if you feel like your back is worn out or you have carpal tunnel, because this is a gradual onset. From there, from that kind of injury, it's 3 years from the date you first knew or should have known about the connection of your carpal tunnel and your workplace activities. Now keep in mind that sometimes in an FELA case, there are other people liable other than the railroad. For example, if you were at a grade crossing and a log truck pulled into your path, well, the railroad might be liable to you for failure to train you what to do in the event of a grade crossing. The railroad might be liable for not having adequate grade crossing protections. The railroad might be liable for not having adequate vegetation control that allowed the crew to see the truck and the truck to see the crew. And that's all fine. That's a Federal Employers' Liability Act claim, and you have 3 years. But the truck, too, might be liable. The truck might be liable for failure to stop for the train, failure to yield the right-of-way to the train, failure to stop at a stop sign. Trucks do some stupid things out there. Well, if the truck's liable at all, the truck needs to be considered a potential defendant, and that's going to depend on where you are. If you're in Tennessee, for example, you have 1 year, or your claims against that truck are lost forever. Georgia, Alabama, West Virginia, for example, you have 2 years. Florida, you would have 3 years. It varies in every state, and it's important that immediately after the event, you contact counsel and say, what are my time limits? Get that, write it down, don't forget about it. Now, it's very important not to be fooled by the claim agents about these time limits. Way too often over my career as a railroad lawyer, I have seen claim agents lead people along. For example, a grade crossing case in Tennessee where a dump truck, of all things, was racing a Mustang. The dump truck not only lost the race, but broadsided the train and severely injured a conductor. Well, the railroad had no responsibility at all for that event, but the railroad claim agent, for reasons I'll never really understood, strung the conductor along for 12 months, gave him a little money here and there and said, don't worry, I'm going to take care of you. Well, around the 13th month, the conductor says, can I have some money this month? And the claim agent says, nope, you're on your own. At that point, the conductor calls me and says, Michael, I need help. This dump truck ran into my train and I'm severely hurt and I'll never work again. I said, is it the railroad's fault? He says, I can't think of a single thing the railroad did wrong. I said, well, you've waited too long. Claim agent led him astray. And he could have stopped that by calling a year earlier or even really a month earlier, and we could have saved that case for him. Now, what do you do if you're injured? Well, the most important thing is to make sure you tell your crew members at the time. There's really no substitute for getting back up onto the locomotive if you think you're hurt and say, Joe, you know, that switch was tough. I think I've hurt my back. Even if you don't want to report it that day, and I encourage you to report it. I encourage you to file Form 22s or PI-1As if you're with CSX. But if you don't, and I know there's legitimate reasons not to because they will fire you, unfortunately, you need to make sure your crew knows. Pinch them. Make sure it's memorable to them. When you complete your Form 22, call somebody first, if at all possible. We can walk you through the language to make sure you do it in a way that's truthful, but yet helpful to you. Again, using an example that I've heard too often, a man who gets hurt on a defective switch will describe that event as follows. I walked up to the switch, I snatched it up and hurt my back. Now, that's not what he did at all. What he more likely did and what he should have written down is, I walked up to the switch. I inspected the points to make sure that they were not impeded. I inspected the switch to make sure it was not locked, tagged, or spiked out. I then bent down and unlocked it. Keeping my back straight and my knees bent, I grabbed the ball with both hands. I brought it up in a smooth and easy fashion, just as I had been trained to do when it caught unexpectedly and caused my back to be injured. Now, which of those is a better case? That's an easy question, but you're going to be stuck with what you write down. Call your local chairman. Get them involved early on. Protect your insurance with vacation pay. Keep in mind that you have The remaining calendar year after your last paycheck plus 2 years for insurance for yourself, and the remaining calendar year plus 1 year for your family. What that means is this. If I get hurt in June, and I take all my vacation pay in June, and I never go back to work again, I'm going to have the remaining calendar year of that month, so 6 more months, plus 2 years. And that's the end of my insurance. But if I can think it forward a little bit, get some vacation in December, where my paycheck arrives in the following year, I'll have that year plus 2. Again, this can be handled through talking with your local chairman, manipulating your vacation, and sometimes even moving your direct deposit account. Call experienced legal counsel. Every rail union has experienced legal counsel. Certainly the ones who work for the UTU work with the UTU, who are designated by the UTU. They don't work for the UTU, but are designated, have sort of a seal of approval. These guys have tried cases. These folks are known to the railroad, and they are absolutely responsive to railroad workers. They have to be, because if they're not, the word gets down the rails faster than trains move over the tracks. They will give you good advice, and they will never, ever charge you for that advice until they're retained. And go to the best doctor you can hire. As I said earlier, you have great health insurance. Use it. They don't call them company doctors for nothing. Get a doctor that's in your court. Get a doctor who's going to look after your interest, and most importantly, get a doctor who will make you well, whose interest is in making your life better and your family's life better, not simply putting you back to work to reduce the railroad's damages exposure. Document the conditions and the witnesses. And what I mean by that is, if you've got a camera, take pictures of it. Now, the rule at Norfolk Southern, for example, says no cameras on the property. Well, I have to tell you, you don't worry about violating a rule. You worry about your future. If you fell in a hole, you take a picture of it. If you slipped over a rock, you take a picture of it. If there's a switch that's out of line or has defective or parts missing, you take a picture of it. If a grab iron comes off, you take a picture of it. And if you can't take a picture of it, you write it down. And you make sure that your coworkers see what you're talking about, and you make sure it's memorable to them. Remember, the day you get hurt is the most important day of your life. To them, it's another day at the office. You've got to make it memorable to them. I want to end with this idea. I started with the idea that the Federal Employers' Liability Act is your most important safety friend, your most important tool to have a safe place to work. Well, the railroads don't like it, and the reason they don't like it is because it works. It costs them money. Instead, they want workers' compensation, and they say workers' comp is better. Well, let's look at the facts. FELA is fault-based, but as I've explained to you, if the railroad is careless in whole or in part, no matter how small, the railroad is liable. If you're 50% at fault, the railroad is still liable. If you're 75% at fault, the railroad is still liable. If the railroad is only 1% at fault, the railroad is still liable. So yes, it's a fault-based system, but between the strict liability, which doesn't require fault, and the carelessness, which only requires 1% railroad fault, that's not a tough burden to overcome. Well, they say FELA needs lawyers. Well, workers' comp needs lawyers. If you didn't need lawyers in workers' comp, they wouldn't be advertising on TV all the time. The reality is the defense in both of these cases is the same most of the time. It didn't happen here. We don't know where you hurt your back, but you didn't do it at work. That's what everybody says. They say it at McDonald's, and they say it at Norfolk Southern. You still need a lawyer to help you, to level the playing field. And let me remind you, when you get hurt at work, if it's a serious injury, the railroad's lawyers are there before you're at the hospital. If you lose a limb, if you're knocked unconscious, if you have a brain injury, the railroad's lawyers are there that moment. The claim agents call the lawyers on their way to the scene. Why? Because that way everything they do can be secret attorney-client privilege or a secret work product. Don't kid yourself that the railroad is looking out for you. When you get hurt, they have one goal: maintain profitability, minimize exposure. Well, what about medical? FELA, as I told you a moment ago, you get to choose any doctor you want. Workers' comp has workers' comp doctors. Too often the worst doctors in America. Doctors who can't get a job anywhere else. Doctors who will work for substandard pay. FELA says all damages caused in whole or in part by the railroad's negligence. That means pain and suffering. That means the physical pain. That means the worry. That means emotional injury. That means disfigurement. If your face is burned off in the FELA, you'll get compensation for a real injury, for real disfigurement. If you lose a little finger and you can't play the guitar anymore, you can't play the church organ, you're compensated for that if it affects you differently than somebody else. Workers' comp, you're a schedule on a chart. Actual lost wages. In Georgia, a man making $50,000 a year can't get but $400 a week in comp benefits. In the FELA, he gets $50,000 for every year he's not able to work, plus the value of his benefit package. FELA has a right to jury trial. Workers' comp does not. Jury trial is important. Founding fathers said that it is important, a constitutional right, that people in our community, our peers, judge our factual disputes and measure our damages. Unpredictability ensures safety. Workers' comp, if I have a machine that could cut somebody's finger off if I take a safety feature off, but it'll improve production, I can do the math. This is how much a finger costs. This is how much extra money I'll make. Federal Employers Liability Act, if I make that choice, I'm taking the chance that a jury will make that finger more valuable than the profits I would have made. Railroad Retirement Board coverage. Keep in mind that you do not generally have Social Security when you're a railroad worker. After 60 months, if you qualify for Social Security, you can get Railroad Retirement Board benefits. After 240 months, all you have to be able to do is say, I can't be a conductor, I can't be a trainman, I can't be an engineer, I can't be a clerk in my craft anymore, and you qualify for your pension. Even if you have a college degree, even if you have a law degree, you're going to draw your pension if you can no longer do your craft. And after 360 months, you pretty much have maximized your coverage. Now, why are these dates important? They're important because if you have a claim with 239 months of service, you don't want to settle that claim without getting that extra month of service because you want that pension. Too often, lawyers who don't have the experience necessary to handle these cases won't even know about that. They'll think these are comp cases. They won't know about the pension. They won't know about the real value, and they'll sell you out. And that's something you need to be careful about. So to end, Federal Employers Liability Act does work. If the railroad fails to provide you the reasonably safe place to work, it's going to be liable, and it's going to be liable for all damages, in the words of the United States Supreme Court, caused in whole or in part by its carelessness.